Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-5034. Gengshu Scott He et al., the balance versus Marco Rubio, United States Secretary of State in his official capacity, and United States of America. Mr. Robert for the appellants, Mr. Simon for the appellees.
Mr. Robert, good morning.
Good morning, Judge Henderson. Good morning, panel. My name is Mitch Rotbert. I represent the appellants, June Zhang, her minor children, and her two parents, Wang Jing and Rong Zhang. May it please the court. This appeal presents a rather simple question, which is whether the Zhang's second amended complaint plausibly alleges or allows the reasonable inference that a federal officer, namely Pert, acted in a manner that gave the Zhangs reasonable apprehension of harm and that they suffered such harm. The district court below applied a test that doesn't exist under Virginia law. The test, as articulated in Clark, is that the present ability to cause harm is not a prerequisite or an element of the tort of common law assault under Virginia law. The district court, however, dismissed the Second Amendment complaint on the following conclusion: that the Second Amendment complaint does not plausibly suggest that Pert was poised to injure anyone without significant delay.
Let me ask you this. The Virginia law also says there must be an overt act. What is the overt act, in your opinion?
The overt act, well, there's more than one overt act, and Virginia law counsels us that we should look at the totality of the complaint. That's out of Clark as well.
You've got the officer grabbing Mr. He.
Yes.
And you've got him pointing the gun
Right.
at the child.
Correct.
Are those the two overt acts?
No.
Okay.
There's more.
All right.
These officers came to the Zhang home, their home, on the eve of a Chinese festival. They were dressed in black. They arrived at the house having bypassed a sign that said, "Don't come by here because we're protecting ourselves from COVID." And they banged loudly on the door for 30 seconds. That's the allegation.
Did they have masks on?
I'm sorry, Your Honor.
Did they have masks on?
Yes, they wore masks.
And were they COVID masks?
Well, Your Honor, they were masks, and we didn't plead how, whether they were meant to be,
Okay.
more than what we would have understood to be a COVID mask at the time. And the whole family goes to the front door. And at this point, Pert engages her, is pronounced her, in a connection, in a series of conversations, which has to do with some workplace allegation that Pert has been hounding her for years about. Now, the United States wants you to understand that because it has a workplace genesis, that therefore it is not a common law tort of assault. But I don't think that helps the United States here. I think the fact that these officers came here to bring to the Zhang home an argument that belonged in the workplace is part of the series or totality of overt acts that happened that evening.
So do you think just appearing at their house was an overt act? Obviously it was.
I think so, Your Honor, given the circumstances of appearing there at the house, and to borrow from Fourth Amendment jurisprudence, we know that the home is a sacred space. It is not to be invaded without some degree of real necessity. And I think the inference that we have allowed that's reasonable from this Second Amendment complaint is that these federal officers intended to cause fear in the Zhangs. And the fear was felt. There's no question that this family was in fear. Those are the two elements of the tort. They are satisfied under the pleading standard that we have under Twombly and Iqbal. The problem, if there is one, and it's a very narrow one, but an important one, is that Iqbal and Twombly not be expanded to basically allow trial on the briefs. There's plenty of issues that the United States has raised in their response to our brief that have nothing to do with the elements of the common law tort. And that even presumes that we have to plead the elements. We're not required to plead elements. We're required to plead facts that allow the inference that at trial, those elements can be made. The United States wants you to understand, I think, that there was some degree of consent in the officer showing up on that evening. But consent is not an element. And if anything, consent is simply a defense that they may assert at trial on this.
I have a couple of questions about, to close the loop on assault, there have to be alleged facts that permit a reasonable inference that Hurt and Velez intended to cause harmful or offensive contact with the person, or at least to make them fear
Yes.
imminent such contact. And I wonder what the facts are that you're really focusing on in the complaint, that they were not just there to spook the family or drive home to her, that he wanted him to acknowledge something that Hurt thought He had done, but that actually that there's some reasonable basis to fear imminent physical harm.
So I think this gets back to Judge Henderson's question, and I think Judge Pillard. It's a question of what facts do we focus on for purposes of that element of creating that apprehension of an imminent harm, because it's not required that harm actually have to occur. There's the time.
Right. No, it's that you have to be able to infer that the defendants intended to make the plaintiffs apprehensive that physical harm to them was imminent.
Yes.
Right.
Right. I don't think physical harm being imminent is an element. I think it's fear that the apprehension is imminent is all. And that is set forth in the Clark case very plainly. It's not about the question of causing immediate harm or imminent harm. It's about causing imminent fear of harm. And that is exactly what is established by Hurt's conduct. And if we don't need to look much further than the two examples that Judge Henderson raises, which I think is a core part of the overt acts, which is Hurt reaching through the threshold, grabbing Hu's arm, and then, making his finger gun and pretending to shoot the child and calling him, a racial slur. I think those are sufficient for us to conclude that there was the elements of the common law tort under Virginia law were established.
So as I read the Virginia cases, typically the overt acts to find assault, the overt acts have to be aimed at the victim. And there's a question here whether the overt acts are just aimed at her. Would they have done the exact same? The family weren't there or didn't come to the door. And so the notion that these overt acts or the intent to cause apprehension of physical harm are aimed at the family members. Do you have anything that supports an inference that was the defendant's intent?
I think that inference arises from the fact that these federal agents arrived at the Zhang home on a known Chinese holiday.
Do we have any reason to think that they knew that this was the New Year?
I think what we know is that when they leave, as alleged, when they leave the premises, they make another racial slur. They say something to the effect of that, it's funny they're leaving the Christmas lights on. These immigrants are leaving this Christmas lights on. And we know
It seems to cut the other way.
Well,
They don't know it's Chinese New Year. They're assuming that they're untimely.
I think if we draw the inference in favor of the Zhangs, not in favor of the United States, the inference is, given the totality of the complaint where Hurt is accusing or demanding that He concede something that's still unknown. He's calling him an immigrant. He's saying you're not an American. He's doing all of these things. That essentially, I think, colors the entirety of the event on
Is it
February
important
12th,
to you
2021.
that the defendants know that this is the Chinese New Year? What if we think that that's not been alleged?
If you think that's not been alleged, then I think that's just one factor. It's not the only factor that we rely on.
So for the aiming, if we think the aiming at the victim is important, the aiming at the family, you would rest on that they're going to the home.
Yes,
talk
going
about a
to the home,
workplace.
grabbing the parent who's at the lead. All of them are shuddering behind him. I think that there is an understanding while that continues. It's not like, Pert sees that there's a family, says, okay, I'm backing off and I'll see you in the office on Monday. That's not what happens. Instead, he continues to harangue He in front of his family. I think that's sufficient to allow us to go to the next stage of this case.
We have to look at what inferences are reasonable. Now, if these were known mafiosi, then coming to the house and, saying, basically, we know where you live and being, aggressive about this event, that might be a reasonable inference. But these are government employees and in
This fellow
protective
has been
service.
intimidating Mr. He for months.
Judge, it was more than months. It was over the course of years, nearly.
I think I've heard probably a half a dozen jury issues just in the discussion.
Yes.
But
So
I mean, isn't your, rather than parsing all of this, isn't this the common sense way of looking at this, especially in the light most favorable to the plaintiffs, is that people came, banged on the door, grabbed, unconsented, the head or the father or the leading person, the leading defender of the home, because that's the person who kind of comes to confront whoever's on the other side of the door. And everyone is standing behind the prime defender of the castle and sees this man grab him by the wrist and calling him racial slurs. And notwithstanding all of that, points a finger as if a gun at a child. Wouldn't it be reasonable for at least that child to have some sort of fear that harm could come to them and that a person was intending to place fear in the heart of that child? You don't point a finger looking like a gun at a child to, endear yourself to them necessarily. And since that one count is a group count with respect to one count of assault with all five or whatever of those family members other than He, the only way the government wins is if none of them were, the assault isn't pled with respect to any of those people. So when you look at the big picture here, isn't that really what this case comes down to?
I agree, Judge Wilkins. And I think that the fact that the federal agents came as they did, dressed all in black, and stayed in front of the family, knowing the family was there to continue the harangue that commenced at work against Mr. And acknowledged the presence of the family with this finger gun, puts all of them in apprehension that it's not just Mr. that they're coming after. They came to the family home. That has to mean something under Virginia law, and it does. These are triable questions. We ask that the court reverse the district court and remand for proceedings consistent with our Second Amendment complaint. Thank you.
Right, we'll give you a couple minutes and reply.
Thank you very much, Judge.
Mr. Simon.
May it please the court. I think it's important to look at the allegations in the complaint. Mr. Rob,
One question first. Is this guy Perth still employed there?
he is not still employed. He left the State Department. If I could just give some quick background to, and there are many points I would like to address with the court's indulgence. But first, according to the allegations in the complaint, had not engaged with Pert, I think, for 2 years before this encounter. There had been a 2-year gap because had left the State Department, came back to the State Department. This administrative investigation was still ongoing and hadn't been closed yet. February 9th, according to paragraph 86 or 5 of the amended complaint, he receives receives a communication from Pert to try to set up an in-office interview. We need to remember this is COVID. The allegations in the complaint are that was quarantining. He was teleworking. This incident occurred at 4 p.m. on a Friday during business hours. When you telework, your home becomes your duty station. So
But he was quarantining, meaning, I mean, I see there's no allegation of threat of bodily harm through contagion, but the reason that a person is teleworking and that people are quarantining is so that they will not be physically in the same space as their colleagues.
yes,
So why isn't calling and waiting for an email reply, which apparently Mr. He had sent by the time Parrott shows up, good enough?
well, that with all due respect, Your Honor, this is really just background. I don't believe that's germane to the question of whether the elements of assault have been.
Well, it's a little bit to the circumstances, at least as Mr. Ruppert talks about them, bringing a dispute that belongs in the workplace physically to the home. And you're right to point out this is during work hours, and there's a little bit of difference in characterization where the plaintiffs emphasized that they were getting ready for a family festival, a Chinese festival. The family's getting ready, and it sounds like it may have been on Mr. He's duty hours. But I guess I'm just asking why it isn't a reasonable inference from the allegations of this complaint that at least it's one of several facts that plaintiffs claim are relatively aggressive for the security officer to show up personally at the home.
Merely showing up at a home is not an assault under Virginia law.
No, I know.
You have to
But
have.
is it usual? Is it necessary? It feels aggressive.
Even if the court were to infer it was aggressive, it is not an overt act directed to the family.
What's paragraph 107 of the complaint says? It says Pert then reached and grabbed He's wrist while He was inside the threshold of his home.
Yes, Your Honor.
Isn't that a plausible allegation of an assault against He?
But this is not the claims that HUD has.
Answer my question. Is that a plausible allegation of an assault against He?
Well, Your Honor, it's followed by the statement that he was trying to hand him a business card. So you'd have to
Grab somebody's wrist to hand them a business card? Grab my wrist and you're going to get a 2-piece with a biscuit.
Okay. Assuming it's an allegation of assault by HUD, that is not the assault. HUD may have a claim of assault, although that's been dismissed for other reasons, but that is not an assault on his family.
My point is, And I know that that's not the assault that's at issue in this count because it's the other plaintiffs besides her. My point is, isn't that a plausible allegation of an assault against her that his family witnesses? And then you go further to the complaint to paragraph 113 on the next page, that H's minor children begin to cry and H could feel his wife trembling behind him. And then he proceeds to point a pretend gun at H's son and press the thumb down as if he's shooting. That's paragraph 114.
And
So if they're all watching H get assaulted and they are trembling and crying, and the response to that is to point the pretend gun at a child, why isn't that an intent to cause fear? It's certainly not an intent to de-escalate the situation, at least reading everything in the light most favorable to the plaintiffs.
Your Honor,
Why isn't this a simple case of there's enough that's been pled here, whether they can prove it or not, or get any damages or not, is something else. But what are we doing here?
the standard, there needs to be a plausible allegation that an overt act was capable of causing imminent bodily harm to the victim claiming assault. So it has to be a reasonable.
Where are you getting
or
that from?
apprehension of such conduct, or
Right,
apprehension.
right.
Of such
So
conduct. None of the overt acts has to be capable of causing harm. It has to make the people reasonably feel like I'm going to be harmed.
Right, but the reasonableness part means that the act has to be capable either actually or in appearance of causing harm. That's the Carter case.
It has to be, I think, it has to cause a harmful or offensive conduct or cause imminent apprehension of such conduct. So it itself doesn't have to be. And I mean, if they're grabbing the dad, why wouldn't the kids fear that they're going to grab them? Or the parents
Your
fear?
Honor, if I could, the Carter case and the Kaufman versus Garnett case make clear, in Virginia, it has to be a reasonable apprehension,
Right.
not just an apprehension.
Right. But it doesn't have to be that the defendant has already done conduct that could itself cause harm. And maybe he has here, but that's just to get the standard straight.
Your Honor, I respectfully disagree. I think the standard is that for it to be a apprehension that is reasonable, the act committed has to have the capability, whether actual capability, a loaded gun, like real gun, or apparent capability to cause imminent bodily harm in the moment. Otherwise, the fear, any apprehension is not a reasonable apprehension. All of the Virginia cases, they talk about holding a cane, a gun, if the gun is not loaded, is still an assault because it has the appearance of being able to cause in the moment imminently bodily harm.
In an overt act, I'm reading from Carter, a common law assault occurs, then they have the first, action intended to inflict harm, or if the defendant engages in an overt act intended to place the victim in fear or apprehension of bodily harm and create such reasonable fear or apprehension in the victim. So it's intended to make someone fear that they're going to be hurt and actually reasonably makes them so fear.
It has to be a well-founded fear.
Yeah, right,
And-
right, okay.
And there has to be.
What is unreasonable about the fear of these people?
So we're talking about the family. Whatever happened between the officer and Ha ended quickly with Pert trying to saying, I want to hand you a business card. So at that point, if the children feared for their father's safety, that's not an assault on them.
But wait a
Just
minute.
that.
If you're a child or an elderly parent, and the question is, has a defendant's conduct, was it intended to place me, the child, or me, the elderly parent, in fear or apprehension of bodily harm? And does it reasonably make me fearful? Seeing, as Judge Wilkins was saying, seeing the head of household be actually physically assaulted in his home it seems to me it's reasonable to draw an inference that if the strong one among us is going to be victimized by these bullies, again, reading the complaint, in the light most favorable to the plaintiffs and drawing reasonable inferences in their favor, if the complaint alleges that these two bully, including physically unwanted touching of the dad, how is that not enough to show that they intended to place the children and the parents in reasonable fear for their own bodily safety?
Because that act wasn't directed at the family. It didn't have the potential to physically cause contact to the family.
It doesn't have to itself. It has to reasonably cause them fear that they will be hurt. Not just the act that's happened hurt them.
So,
right?
Virginia law is
Am
very.
I wrong about that?
I disagree. I respectfully disagree.
Tell me what you think the standard is.
Okay.
Just so we could, because I thought that we had agreed a moment ago.
So words alone are not enough under Virginia law. I'm just going to start if I could just build this up.
Words alone are not enough for what?
To constitute an assault.
Because
even
you
if they
have to have the overt act.
Correct. So even if you say, I'm going to kill you, that is not an assault under Virginia law. The reason it's not an assault is because a word doesn't have the actual ability to harm a person, and it doesn't have the apparent ability to harm a person. So you need the overt act has to do one of those two things. And that then, if there is an apprehension, that makes the apprehension reasonable. So here you have, let's assume that the grabbing of Hayes' wrist meets the elements. That was not directed at the family. He was not in reach of the family. The family was behind Hay. He stopped and then handed Hay a business card. He took no steps into the house. He took no steps towards the children. Nothing that would create the imminence that's needed. The hand gesture, I apologize but I'll just make this hand gesture to see this cannot cause anyone actual harm, nor can it cause anyone apparent harm. Is it inappropriate? If it happened, absolutely. It's not an assault.
Actual harm or apparent, it doesn't have to cause actual harm or apparent harm, right?
It's actual, it has to either actually have the ability to cause imminent harm or have the appearance of the ability to cause imminent harm.
Where are you getting that standard, which is a little different?
I'm getting it from Carter. There must be some power. I'm sorry, this is page, this is hard to always, with these, I'm going with the Virginia VA Reporter, page
Are you in
47.
the Supreme Court case or the appellate, the Court of Appeals?
I'm in the Supreme Court case. There must be some power, actual or apparent, of doing bodily harm. And and then there's just a scenario in Carter where.
But apparent power is sufficient, is the next phrase.
Right. And I'm not, what my point there is that's Carter. Carter was a situation where a police officer is doing a traffic stop. The person makes a movement from their hip, arching towards the officer, doesn't have a gun, but that movement in real time, in the moment, created reasonably imminent fear that the officer might be shot.
Right, there's more language in Carter, and that doesn't go to the overt act. It goes to the imminence or the ability to injure someone. On page, I don't know which page you were reading from, I think it was 841, but 842, the court says, the definition in Burgess remains valid. That definition does not require the present ability to inflict harm when, as here, an assailant acts in a manner intended to put the victim in reasonable fear and causes the victim such reasonable fear. And if you say, we don't know his intent, I'll give you that. But that's a jury question. I think we do know his intent, but that's a jury question. We can't say as a matter of law, but a jury has all of this scenario, this inexplicable campaign of intimidation against this man.
Well, but let's talk about the second component, which is whether it's reasonable apprehension. That can be decided by the court. That's an objective standard. And what you just read from Carter is addressing the fact that the driver didn't have a weapon. So he didn't actually have the present ability to harm the officer, but the act created the apparent ability to harm the officer.
But
that's enough.
One fact situation in which, it seemed to the officer that he had a gun. And so there's actually quite strong testimony there that the officer in the moment was fearing for his safety when the passenger went like this. But that's not required. I mean, I think there's both before that passage from Lynch and after the part that Judge Henderson read and the prior, at least this comes out in my version, the prior column, we conclude a common law assault occurs where an assailant engages in an overt act intended to place the victim in fear or apprehension of bodily harm and creates such reasonable fear or apprehension. They don't have to have done any act that seemed to be capable of, at that moment, causing harm.
Well,
That is the fact of with the in Carter, but it's still, I think that's not saying that is always the way that we apply this standard.
If that's the case, then words alone would be sufficient.
Well, there has to be overt acts. What's your response?
May I make
what's your response to the Mr. Roberts saying that the overt acts are many, coming to the home, bringing a dispute to the home that belonged in the workplace, banging hard on the door, being dressed in black and masked, and leaning into the threshold and grabbing her. Those are all acts. What makes them not, in your view, overt acts under the assault provision in Virginia? Even
if you take the characterization of Mr. Roper, acts preparatory to a future battery are not assault. And so let me give an example. We have a disagreement. We say, we stand up. Looks like there might be something to happen. I take my glasses off. That is an overt act. But the act of me taking my glasses off and putting them on the table is not capable of causing anybody harm. It doesn't have the appearance of having harm. If I get into a position with my fists up, now suddenly I'm in an overt act where I actually have the capability of causing imminent physical harm. So the knocking on the door, none of that is causing the family the imminent fear, reasonable apprehension of imminent harm. He didn't have to open the door. He opened the door. He could have shut the door. There's no allegation he tried to shut the door. These were business associates.
What about the grabbing of the arm and the wrist?
So assume for the sake of argument, that's an assault on Hay. It's not an assault on his family because that act could not have physically reached them.
So it's not plausible or reasonable to conclude that act was intended to place both in fear and people watching in fear.
Well, but I'm focusing, Your Honor, on the question of whether that created a reasonable apprehension of imminent harm in the family. Even if you accept that it was intended to instill fear in the family, that's not enough. It has to create a reasonable apprehension of imminent harm in the family. And the family witnessing harm to their father.
Virginia law, what does harm mean? So are you saying that, let's suppose the case that we were dealing with was Huh? Does he have to plead that somehow he was injured under Virginia law, when his wrist was grabbed?
No, I don't know about for battery, but for assault, he just has to plead the physical contact was imminent.
The unconsented
Physical
touching
contact, yes.
is the harm, right?
Well, that's the standard is essentially that you're at risk or you are reasonably apprehending imminent physical contact as a result from the act itself, the overt act itself.
Exactly, my point exactly. So the basic question is, if it's can be done to Mr. Huh, why wouldn't the children or the parents or the wife think that he could brush past Mr. Huh and grab one of them?
Well, that might,
Why wouldn't that be a reasonable fear for them to have?
because he didn't make any movement toward them. So that he has to take an overt act towards the children. If he tried to enter the house, tried to move past
He
it,
engaged the children, or at least one of them.
but not, he didn't, there was no, that act that you say he engaged a child with was not capable of causing that child
Oh, where you're
harm.
getting this capable of causing harm, you keep coming back to that. And we've had, I think, 3 exchanges already where I've probed where you're getting that from, because the definitions that I read from Carter of this generally applicable standard, not the facts in Carter, which, where the officer did think that actually a gun was being pulled on him. So yeah, he did think that he was about to be shot, but that's not the statement of the standard. That's a statement of the facts that met the standard. And the standard does not talk about overt acts that are themselves,
But
except for some misapprehension.
it's the difference, Your Honor, between having subjective apprehension and reasonable apprehension.
Not really. That doesn't track that. I think the reasonable apprehension is, would a person in the situation who's not highly nervous or.
And Your Honor, I'm sorry, I apologize. I hope I'm not interrupting, but also the imminence is also factored into that. So
if Parrott punched the father in the chin and the children were right up behind him and the parents right up behind them, would that be enough to intend to create the harm and reasonably cause the harm?
that would certainly get much closer because you have to.
Would it? I mean, no or yes? And then you can explain. I just need to have a sense of where your position
If he
is.
hits Huh and Huh falls to the ground, and then he's now staring there after knocking out his father, facing the children, that would create a reasonable apprehension of imminent harm to them. But here, he grabbed momentarily because Huh pulled back and said, you have to respect COVID distancing. And then he said, I want to hand you a business card. So
Did he say that?
that's what it says in paragraph 96, I believe, of the complaint.
I'll take your word for it.
I hope I have it right. It's 95 or 96. So that's the context. And this is a business. Huh is there to do business with the father. Maybe he's allegedly doing it in an aggressive manner, but
Huh is the father. So Hurt is there to do business with the father.
Hurt is there to do business with Huh. It's a business related conversation. How does it end? He leaves his business card and leaves. So this is, this is not the type of act towards a third person that can put other people in reasonable fear that they're about to have imminent harm to themselves. He needs to do some other overt act. The only other overt act he did was a pretend hand gesture. And that is not capable in the moment of creating reasonable fear. I'll also just note in paragraph.
Do we know whether Hurt is packing?
So, Your Honor, there's no allegation that he's armed. There's no allegation.
He is a security officer, though, right?
Well, he's known to Huh to be a law enforcement officer at state. I just want to make clear, my understanding is that typically these officers are armed, but what's important here is there's no allegation that they saw any weapon on him. Remember, this is February 2021. I think it was 32 degrees out. Probably were wearing.
I'm getting at, I had asked you before whether, no, I guess I had been asking Mr. Robert, if Mr. Parrott were a known mobster, that it seems to me would make your case much harder. Of course, you wouldn't have to defend that case.
And he was to Mr. Ha. He had intimidated him in the office, at least according to this complaint, repeatedly. And I don't know that you know what he was talking about, but I thought you said he came to conduct business. I thought at some point he said ambush. Am I wrong about that?
That's an allegation that one of the statements he made was
Okay.
ambush. Yes, that's
All right.
correct. But the children and the family, there's no allegation they knew about any prior conduct by Pert to Ha.
Well, what the family knew was that, according to the complaint, Hurt repeatedly cursed at her and said COVID was caused by people like you, and uttered a racial slur at the child. And I'm not going to repeat, at paragraph 114. So you think that minorities, immigrants, people of color, if they have racial slurs hurled at them and are being cursed at, that doesn't plausibly create a fear of harm, an apprehension, a reasonable apprehension
I'm sorry.
of harm?
Those allegations are certainly disturbing if they happened. I'm not saying otherwise, Your Honor, but there was no threat to do violence. And that's what you
Well,
need.
my experience, racial epithet and cursing are common prelude to violence.
But there needs to then be an overt act.
Is that fair? Is that a fair? Is that a fair inference based on how we know the world works?
Well, certain racial slurs, certainly, Your Honor, but the question.
Only some.
Well, I don't know specifically what the court is contemplating. Saying that you didn't have immigrants don't put away their Christmas lights.
I'm talking about what's in paragraphs, 113, 114, 116.
And fundamentally, Your Honor, there still needs to be, none of those were directed towards the children other than the last one. But to be clear, the last one, according to paragraph 114, was muttered, meaning it was made under his breath. That's what muttered, that's the definition of muttered. And the child was several feet away behind the father and the mother.
Okay, so we're
we don't
supposed to take all of that in the light most favorable to the plaintiffs and say, because they alleged used the word muttered in their complaint, we can infer that they didn't really hear it.
Even if they heard it, it was muttered, so it was murmured. So that's not stated in a threatening way. I'd also just point out that in paragraph 114, they never allege that the family actually experienced fear from the pretend hand gesture or from that statement. They make that statement in paragraph 113 regarding the grabbing of Hu's wrist. They never make it with respect to the this other overt act we've been discussing. And if you look at their
Paragraph says began to cry and he can feel his wife trembling behind him.
yes, that's related.
So when people cry and trembling, isn't it reasonable to infer they're in fear?
In fear of what happened to their father, but not
Okay,
necessarily.
So he's got to allege that it continued and didn't stop in order for us to, or otherwise we can just discount all the allegations that happened after that in the complaint. That's the way you say we're supposed to do this?
What I'm saying is, Your Honor, is that if the children had fear from what happened to their father, their fear about what happened to his person is not an assault on them. For that to be assault on them, it has to cause them fear that their bodies will be imminently contacted. And what I'm saying is they have not made plausible allegations. They don't even allege they had actual fear of that in paragraph 114. And if you look at paragraph 198, that's their assault cause of action. Their basis for alleging reasonable fear is the grabbing of Hu's wrist, not what's described in paragraph 114.
All right.
If I have any further questions,
Thank you.
we would respectfully request that the court affirm the judgment bullet. Thank you.
Thank you, Your Honor, for allowing me another 2 minutes. I won't use all of it. I direct the court's attention to paragraphs 121 and 122 of the Second Amendment complaint, which alleges that for several weeks, Hu's 4-year-old son wet his bed and was unable to sleep alone. Both of their sons were unable to sleep alone. And at 122, the Second Amendment complaint alleges that the elders, Ron and Wing Jing, who are survivors of the Cultural Revolution in China, experienced insomnia and depression and were frightened that this would recur. I think that's sufficient allegation of fear.
Can I ask you your briefing relies on how Virginia has adhered to the second restatement of torts, and the section 26 of which says to make the actor liable for an assault, the other must be put in apprehension of a contact with his own person. And then the comment adds, it's not an actionable assault to make another fear that the actor will intentionally inflict a harmful or offensive bodily contact upon a third person, no matter how closely connected with the other, by ties or blood or affection. So, and it goes on to talk about, if you're afraid that your wife or your child is going to be harmed, even though that's really anxiety provoking, that isn't enough. And I just am interested in your response to that. How do you deal with that?
Thank you, Judge. I think that that part of the restatement is articulating something very specific that doesn't apply here, which is where someone is told words or overt acts are directed at someone, and some third person is a part of that threat. I think that this is a lot different because Hurt is addressing the family together.
Before you shifted to this case, you said, and the other third party is not part of that?
The third party isn't present.
Is not
present.
Okay.
I meant to say present. I mean, everybody's there. They're an audience to Pert's performance.
Not just an audience, but they're facing
him, and they're behind. They're the strongest member of their family who's trying to protect them, and nevertheless he's still assaulted and an unconsented touching.
So, like, if you're the parent at the going to pick up your kid at school, and you see them on the playground,
that's the example.
The bully is hitting your kid. The fact that you're witnessing that isn't enough.
That's too distant. Yes, Your Honor.
And that's what you think this is addressing.
That's what I think, Your Honor. We ask the court to reverse and remand. Thank you very much.
Case number 24-5378. Friends of Animals versus Martell Williams in her official capacity as Principal Deputy Director and United States Fish and Wildlife Service, an agency of the United States Appellants. Mr. Anderson for the appellants, Mr. Herney for the appellate.
Good morning.
Good morning, Your Honors. May it please the court, Christopher Anderson for the Fish and Wildlife Service. I'd like to begin by addressing the timeliness of the appeal and then move to the merits. On timeliness, the July summary judgment order was not a final decision and did not start the appeal clock running. And I think the easiest way to see that it was not a final decision was that the district court had not finished with its proceedings on the remand. A decision is not final and appealable until the district court has finished its consideration of the case. That is the lesson of this court's decision in St. Mark's and the Supreme Court's decision in Schaefer Brewing. Plainly, Judge Contreras was not finished with the case when he entered the July order because he ordered the parties to confer and submit proposals on the remand, and he contemplated entering a further order in the case. The July order was also not final because it did not finally determine the remedy. As we explained in our brief, the parameters and schedule of any remand order are material parts of the remedy, and they very much bear on an agency's decision regarding whether and what to appeal. Consistent.
Can I ask you,
Please.
just pivot to the merits and ask you,
Sure.
has the service ever argued in any other case that Section 4E does not allow it, based on a similarity of appearance, to apply 4E to a species already determined to be threatened under 4A, and so treat it as if it were endangered? Have you taken that position in another case?
The service is not taking that position in another case because this question has never arisen in a judicial case before, as far as I was able to tell through my research. But the service did in its regulation, which it promulgated in the early 70s, mid 70s, interpret Section 4E to only apply to species which are not listed as endangered or
You
threatened.
say that, but to me, actually reading, I may be missing something, but which is why we have oral argument. The regulation actually seems even more amenable to being read the way plaintiffs read the statute, the way Friends of Animals reads the statute, than the statute itself. I'm not sure how you get, because it doesn't have the same unlisted.
Well, it does. 50 CFR section 1750 says, whenever a species which is not endangered or threatened closely resembles an endangered or threatened species.
Right. And given that the statute has sort of two circumstances, it can be a threatened species or it can be an endangered species, why don't we understand that as speaking sort of separately to the two distinct levels that would otherwise be applicable? It just seems like at least the statute is ambiguous. It's basically saying it's giving authority. One way of reading it is it gives the regulation and the statute is giving authority to the service to treat any species as endangered, even though it is not listed as endangered. And it gives the service the authority to treat any species as threatened, even though it is not listed as threatened pursuant to 4A. So that's one way to read it, to say it's not listed as such. You know, you can treat as endangered, even though it's not listed as such, treat as threatened, even though it's not listed as such. What about the language of either the rule or the statute forecloses that reading?
So I think that reading is most clearly foreclosed by the text of the statute in paragraphs A and
so
C.
The rule doesn't really add.
Well,
because there it says unlisted, right?
Right. The statute says unlisted. I think grammatically speaking, I would say the clause that begins, which is not endangered or threatened, means that the species must not be endangered or threatened. Is there some ambiguity there? Possibly. That is certainly the way the service has always understood that regulation, is the way the service has applied the regulation consistently for the last 50 years. And also, I think that the regulation needs to be read in parity with the statute.
I thought that you would point to subparagraph A, so EA, which says a species which has been listed pursuant to such section, and the overall structure of the act, where this whole subparagraph E, similarity of appearance cases, appears kind of after and assumes, the way I read it anyway, is that it assumes that you've already done the listing in the criteria for whether you're going to put something on one of the two lists, either the threatened list or the endangered list. That's described in subparagraph A. And then other procedural matters are in subparagraph B, and including what to do if you're going to move things from one list to another. And then C describes like the lists themselves and the significance of being on the list. And then D is the regulations that you're supposed to pass and enact for the things that are on the list. And then you get to E, which is, well, if you have some things that aren't on either list, and it speaks as if like the lists are already existing, something that has been listed, you can treat it as if it is on a list.
Yes.
Regulations are defined the same way. When they say endangered or threatened in the regulations, those words are defined in the regulations to say things that have been designated on a list.
Yes, Your Honor, that's how we read the statute. And I agree with Your Honor that that the inapplicability of 4E to listed species is most clearly presented in paragraphs A and C of 4E. But to Your Honor's point, I think one way of thinking of 4E is it's an exception. It allows the service under certain circumstances to treat an unlisted species as endangered or threatened, even though it is not, right? So it doesn't have any applicability to a species that is already listed because the service has its authorities under 4D, under Section 9 to institute conservation measures for a species that's listed. It doesn't need 4E authority to do those things.
Okay, I take your position to be that it's not really, nothing is lost by reading the statute to mean not listed at all. And once something is listed pursuant to 4A as threatened, the reason nothing is gained by then considering the treated as to raise it to effectively treat it as endangered is because once you have a species listed as threatened, all the enforcement authority or the protective authority that accompanies an endangerment listing is already available to the secretary. Is that right?
That is correct,
That is your
Honor.
position.
That is our position, yes.
And is that pursuant to 4D?
Yes, Your Honor.
But I thought you say that a species that is treated as is not listed.
A species that is treated as is not listed.
Right.
That is
listed
correct.
is pursuant to 4A, but if it's
Right.
treated as pursuant to 4E, it's not a listed species.
Correct.
Right? But then 4D, the authority in 4D is triggered by whenever any species is listed as a threatened species, the secretary may by regulation prohibit any act, blah, 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 blah. But you're reading D to allow, oh, right, because this was listed as.
Correct, yes.
Okay. Sorry about that.
That's okay.
So, and I guess I'm having a little bit of trouble given the discretion that the service has
Yes.
under the statute, even with respect to a species that is treated as endangered. Why does the service fight this interpretation, which is not requiring treatment as endangered, but only allowing it? What's the downside? Like, I'm having a little trouble with both sides, given the sort of the discretion and the.
Sure, understandably so. So it creates an additional level of analysis that the service would have to perform in any case when it's considering the listing status of species that resemble each other. And remember, it's not just species like the macaws that the individual animals closely resemble each other. It's also in circumstances where animal parts resemble each other closely. And so the service would then be required to undertake this analysis in a lot of cases, adding to its already voluminous workload and frankly, the backlog of work that it has in processing listing determinations.
But I guess that seems sort of circular to me because if they really do look alike, you're going to be wanting to consider that anyway, even if it's only at the threatened level. You know, if you've got bones and feathers. And I mean, you've got to address it, but you're just saying you don't have to have a rulemaking on that.
You don't have to have a rulemaking on it. You don't have to address similarity separately. So in this case, the service certainly considered what measures were necessary to conserve both the northern subspecies and the northern distinct population segment, and considered what commerce measures in particular were necessary when it issued the 4D rule. But then it didn't then go on and do an additional layer of analysis to say, even though we think based on our discretion under 4D that that's sufficient to protect the species, should we also consider maybe treating the northern DPS as an endangered species as well? And that's what the district court required the service to do in this case.
But there's already a rule being promulgated pursuant to 4D to say why you're not going all the way to the full suite of treated as endangered, right? Or as
yes.
So there's already a rule going out. So a sentence that says, we don't think this, and this is also the reason why we're not doing a look-alike upgrade.
Right.
I'm not sure I see the burden.
It's perhaps not an extensive burden, Your Honor, but it is a marginal additional burden. And we also think it is important to clarify, as Judge Wilkins was explaining, sort of the structure of the act and how it works, right? And so once the service has determined that a species should be listed as threatened, the service proceeds to consider a 4D rule. And that's the appropriate forum and framework for the for the service to consider that species. And 4E is an additional step that the service applies to other species that do not meet the criteria for listing. And it helps to keep those categories distinct and avoid the confusion that sometimes occurs, and I think has even occurred a little bit in the briefing in this case, over whether a species treated under 4E is actually listed.
It's just very odd to think that if in this case, for example, 4A had not been applied to determine the listing status of the southern subspecies is northern DPS, that it would have been open to the service based on the acknowledged lookalike characteristics to treat it as either threatened or endangered. But just because of the sequencing of the consideration, I guess maybe this Judge Wilkins' question has in it the answer to this, just because the service said, well, this is actually threatened under 4A, that you no longer have even the authority to consider just putting it as endangered and having a uniform treatment. Maybe that's easier to implement at the border. I just don't.
I think the answer does lie in the order of operations, Your Honor, and the way that the service structures its listing determinations. But I would also say, once a species is listed as threatened, Section 4D expressly gives the service the power to apply any conservation measures that are authorized by Section 9 to that species. So the service loses no authority to protect the 4D species, the threatened species. We think that in protecting the threatened species, it will necessarily protect a similarly appearing endangered species, since they're facing the same threat. By definition, if this even comes into play.
If a species is, go with the fish, Friends of Animals analysis for a moment, if their way of reading the statute is correct, still a discretionary choice on the part of Fish and Wildlife. In the September 9th publication of the Federal Register, in compliance with the remand to the agency, the Fish and Wildlife Service says, in most cases, treating a species as endangered under 4E, where it is threatened, has been determined to be threatened under 4A, would actually provide it with fewer protections, because a species treated under 4E as either endangered or threatened doesn't receive the critical habitat protection, the recovery planning, and the consultation with federal agencies when they act in ways that could affect species that that are triggered by a listing under 4A. And that I found that both compelling and confusing, because presumably treatment as endangered under 4E could layer on top of listing as threatened under 4A, no? I mean, you would still have the consultation and habitat designation authorities that wouldn't go away because one is a listing and the other is treatment as.
Right. So I think the service's Federal Register notice needs to be understood as applying its interpretation, its current interpretation of 4E, that 4E wouldn't authorize that. And I think if this court were to hold, if this court were to hold that the service is wrong, I think the service would, I think that question is open as to whether those additional protections could be layered. In other words, whether a species could be listed as threatened, receive whatever protections were appropriate as a threatened species, and then also layer on some additional, to use your honest
I
word.
thought that I read this Federal Register notice quite explicitly to be explaining why the service's interpretation is better, and saying that under Friends of Animals interpretation, it would be problematic because a threatened species would have fewer protections. But I don't see that.
I think that certainly that result is not compelled by the text of the statute. I think what the service is referring to is its current practice for how it approaches 4E species. And if it were to continue with its current practice with 4E species, that would be the result. I think if it turns out the service is wrong about what 4E means, and that the service can, in fact, treat a listed threatened species as endangered, then I think the service would probably look at those authorities and practices again. But that's another reason why the service would prefer not to have that additional authority, because the system as it's in place now has worked well for 50 years. And
It also hasn't really raised this precise.
It has not. That's correct. That's correct.
So just to help me out here, what is the difference between the practical difference in terms of the tools available or burdens imposed on the service between treating threatened 4A listing and an endangered 4E treated as?
Okay, so if a species is listed as threatened under 4A, the service may apply any of the conservation measures that apply to that automatically apply to a listed endangered species, and all of the other protections that apply to all listed species, such as the federal consultation requirements, apply to that species. If the service treats a species as endangered under 4E, then the service has discretion, and 4E is clear on this, that the Section 9 prohibitions don't automatically apply. It says the secretary, to the extent he deems advisable by regulation or commerce, can apply any of the protections that would apply to an endangered species. But that species which is treated under 4E, because it's not a listed species, does not benefit from other provisions of the Act, such as the federal consultation requirement, the critical habitat requirements, et cetera.
They don't automatically benefit, but if they had an underlying 4A designation as threatened, they would be able to. The secretary may apply those.
That certainly is a plausible reading of the statute that I haven't taken a position on in this case, but yes.
Yeah. And there is this, you take the position that treated as is not a listing.
Yes.
Is there any kind of practical challenge? I mean, I assume the lists are actually lists, and that if you're at the border, you have a list, you have the endangered list, you have the threatened list, you have instructions how to, or probably it's now all searchable wonderfully on computer. Is there any obstacle to implementing the scheme that I'm imagining? And I've been helpful in explaining your position on it, where you have a 4A threatened listing and a 4E endangered treated as. Is that like somehow a morass, or what is the practical response to why that would be problematic?
I don't know that I would characterize as a morass, Your Honor, but I think it would potentially create additional confusion, because then you're going to have a circumstance in which you have species that are listed as threatened or endangered, species that are treated as threatened or endangered that don't ordinarily receive these additional protections, but some of them do because they're also listed as threatened or endangered. So instead of having, 3 categories, now we have, what would that be? 5 categories. The Endangered Species Act is already very complicated. It poses compliance difficulties for the public. It imposes compliance difficulties for other federal agencies that aren't expert in its requirements. And the simpler that the service can make things, the more effective we think the implementation of the act will be.
But you already basically have bespoke rules for every species, unless you're just treating everything as the max. Right?
Yes, there are bespoke rules for some species, and there are default rules for other listed threatened species. Yeah. Yes.
What if we were to conclude that this argument, specifically that the service has the authority to treat a threatened species as endangered under Section 4E? What if we conclude that that argument was not made by Friends nor any other commenter during the rulemaking? Does that affect the jurisdiction of either the district court or us in hearing this case?
It doesn't affect your jurisdiction, Your Honor. I mean, certainly the court could reverse on the ground that the issue wasn't presented to the agency in a timely manner. That's not an argument that we raised in the district court. And for that reason, we thought it would be inappropriate to seek reversal on that ground in this court. But certainly we think that the procedural default is potentially another reason why the decision should be reversed. But it goes to the merits, not the court's jurisdiction.
All right, thank you. We'll give a couple of minutes to reply. Mr. Hernandez.
May it please the court. My name is Stephen Hernick, and I represent Appellee Friends of Animals. In this case, the agency is asking this court to bless a very strained interpretation of the statute that is both contrary to the plain language of the ESA and clearly contrary to the purpose of the ESA, which is to provide protections for threatened and endangered species. But for a number of reasons, this court should never even reach the merits of that question.
I'd like to ask where I left off with your friend on the other side. Where in the comments did Friends of Animals, your client, make this argument?
Yeah, I can't point to anything in the record before this court, Your Honor, about that. But to answer your question, it's not an issue that the agency raised in the district court. It's not an argument that the agency raised before this court. It's not a jurisdictional hurdle to this court. To the extent the agency ever wanted to raise that argument, it failed to do so, and therefore it waived that argument. And that is an argument, the administrative exhaustion that can be waived. That's not a jurisdictional hurdle to this court's consideration.
Okay, let's go into the merits. The way that I read this statute overall, or basically 1531 at SEC, is that list is a term of art. This is all about whether you make one of the two lists, the threatened list or the endangered list. And so whether you say not listed, unlisted, has not been listed, doesn't matter how you say it. It's all about, like, are you on the list or not? And if you think about it that way, to me, this seems like an easy case. It's unambiguous that it goes against you because it says any species, but it says even though it is not listed, that phrase is modifying and describing what you mean by any species. And then you go on to subparagraph A, and it says a species that closely resembles in appearance a species which has been listed. And so when you combine that with the fact that E appears to be dealing with a process that kind of happens after the listing, because all of this stuff that's in the preceding sections are leading up to the decision of listing, and then what happens with promulgating regulations once something is listed, that none of that comports with the best reading of the statute being what you say that it is. So tell me why I'm wrong.
Okay, respectfully, I do disagree, Your Honor. Our view and the district's court view is that Section E is a broad grant of discretion to the service in this case. Congress chose to use the phrase any species. And in this case, the agency has not been able to come up with any plausible meaning of what that terminology could mean.
Well, you look at it by reading the rest of the sentence.
Sure, you have to read the
Even
rest.
though it is not listed, it means any species. That's what it refers to, right?
The language is treat any species as an endangered species or threatened species, even though it is not listed pursuant to Section 4
So it
of this
means
Act.
species, right?
It is referring to species, but the even though language is not imposing a limiting condition on this. It's the service wants to read the even though language, wants to substitute only if for these words. And that's simply not what the plain meaning of that language is. And the service hasn't cited any authority when an even though clause has been read in a way such as this.
But you read the rest of the sentence, it says treat any species as an endangered or threatened species. So it is setting up a construct where you treat it as if it is something else, even though it is not one of those two things. That's what this means.
Respectfully, I disagree, Your Honor. It's giving the service broad discretion to treat any species as endangered or threatened, even for those species that are not listed pursuant to Section 4A. And this is a unique provision of the ESA. It's the only provision in the entire statute that gives the service any discretion to list or treat a species as threatened or endangered that doesn't otherwise qualify under the enumerated factors under Section 4A. So it's not at all surprising.
What does 4D do?
4D gives the service discretion about what regulations should be applied to listed threatened species. So when the service lists an endangered species, the protective regulations of the Endangered Species Act automatically apply to endangered species.
And doesn't that give the service the authority in its discretion to treat and something listed as threatened under the same regulatory requirements as if it were listed as endangered?
It absolutely does give the service that discretion, Your Honor, but
And
often
doesn't that then end your case?
no, because oftentimes the service doesn't exercise that discretion, like it didn't.
That means that this language is superfluous.
I disagree that it's.
What's the point of it if you can do the same thing under E?
Sure, I'll explain why, Judge Wilkins. The language is not superfluous because Section 4D is providing the protections. It's for the protection of the listed threatened species. 4E is not intended to protect the lookalike species. It's pretended to protect the already listed species. from similar looking species being laundered, from that endangered species being laundered as the similar looking species that has fewer protections. So there's a case, and it's not a far-flung hypothetical, because it is essentially the facts presented by this case. The service.
Why couldn't under 4D, the service say, we've only listed this as threatened, but because it's similar in appearance to this other species that we've listed as endangered, and we are fearful that that could the disparity of the listing could put the endangered, the species listed as endangered in jeopardy. Use that as a reason to apply 4D to regulate the threatened species as if it were endangered. What would keep the service from doing that?
I'm not sure if that would be an appropriate use of 4D.
Why not? What in 4D prohibits the service from doing that?
4D is directed towards that particular species. So 4D doesn't give the service discretion to.
It says, as he deems necessary and advisable for the conservation of such species, and may by regulation prohibit with respect to any threatened species, any act prohibited under et cetera, with respect to endangered species.
Sure.
So where would that prohibit or be arbitrary and capricious for the service to use a similarity of appearance analysis, so to speak, to do that?
Well, the language "such species" I think is clearly applying to the listed threatened species in this case. So if the service determined that, in this case, the endangered northern subspecies of scarlet macaws, there was a real threat to that northern subspecies because of people potentially laundering it as the northern DPS, even if that wasn't a threat to the northern DPS itself and didn't warrant protective regulations for the northern DPS. 4E would allow the service to provide that greater protection to the northern subspecies.
And they have that protection. They have the authority under their interpretation of the statute and the regulation to apply the additional protections associated with a required, in the situation of an endangerment listing, to the northern DPS of the southern subspecies that is listed only as threatened. They have the authority to do that. Your point is that they, as a remedial matter, your point is that, what do you get from your interpretation other than more explanation and rulemaking? That's the only thing at stake here, right? Is more explanation and rulemaking. There's not a difference between the authorities or obligations of the service under either interpretation.
The service clearly has a great deal of discretion under these provisions of the ESA. What is at issue here is the agency pressing on this court to read this language much more broadly and say that this provision actually forecloses, completely prohibits the service from applying it in this way.
From treating the species listed as threatened under 4A as treating it as endangered as a protective matter for the northern subspecies. But the only difference in the real world in terms of authority or obligation on the Fish and Wildlife Service is that where they've disavowed the authority to do that, you're saying, no, you have the authority to reach the same practical end in terms of protections through 4E treated as elevating 4A threatened to 4E endangered. You have the authority to make that move And the only thing that rides on that from your briefing is that if they have the authority to do that, they have to explain why they're not doing that.
I mean, perhaps it would lead to the same conclusion, Your Honor, but I don't think it's a foregone conclusion that it would. And the statute shouldn't be read to assume that the same conclusion would result in all instances.
But if they're thinking about lookalikes, which they clearly were thinking about with macaws because of how they dealt with the southern DPS of the southern subspecies, which was treated as, right? They're thinking about lookalikes. They acknowledge that all of these different population segments are lookalikes. They're thinking about protecting habitat. They're thinking about agency action obligations. They're thinking about importation and commerce, and they're actually making a set of species-specific rules about which protections apply. So they're doing all that in a rulemaking that is more bespoke than the default, treat everything as endangered.
Correct.
What more would you get? I'm not really following why they're fighting it, and I'm not really following why you're fighting it, given that the discretion to do the things that you want seems to be there even under their interpretation, and the latitude not to do what they don't want seems almost completely to be available under your interpretation.
Yeah, I think the agency has kind of made clear in this case it's not going to exercise this discretion
Because
even if
it's
it
already explained
even
in a
if it
pretty
had.
nuanced way what it wants to do, and could do that could come out the same way.
Potentially.
Would have the authority to.
Potentially.
No, would have the authority to.
They
They
clearly
would have the authority to, whether they would or not. And so that's what I'm trying to understand what's at stake from your perspective. If they were determined to come out in substance, in terms of the protections, the same way that they've come out under their reading, under your reading, they could, right? If they were determined to do that.
They potentially could. I don't dispute that they have discretion.
And the nudge that you think that your reading provides that their reading lacks is what?
The service is pressing this interpretation that forever forecloses it from applying these protections.
But no, that's not right. It has already the authority with respect to species listed as threatened.
Under 4D.
Under 4A, it has the authority under 4D.
Correct.
To go all the way to pedal to the metal and do exactly what you would prefer.
It certainly could.
It has that authority.
It does.
And under your interpretation, it would have the authority to not use the lookalike power under 4E to treat a threatened species as endangered for purposes of protecting the northern subspecies. It would have the authority to choose not to do that, right?
Yes, the service would still have discretion to choose not to, but they would at least have the option to.
But it doesn't get them anything different.
Potentially it could, because.
What does it get them that's different? Potentially it could give them a different nudge. Like, I need clarity on.
Sure, because here, the northern.
I'm not just frustrated with you. This is very complicated.
I understand, Your Honor. Because here, the northern subspecies is listed as endangered. The service believes it's endangered. The northern DPS is listed as threatened, has this protective regulation that the service has determined is appropriate for the protection of the northern DPS. But the service hasn't determined that, whether that protective regulation is necessarily protective of the northern subspecies with respect
to lookalike problems.
To potential laundering issues. And there's just this, and you touched on it earlier, Judge Pillar, there's this just very strange, absurd result that happens where if a species is unlisted, the service does not believe it requires protection under the Endangered Species Act. They can treat it as threatened, endangered pursuant to 4E. But if a species is listed as threatened, they're foreclosed from doing so. And then that just makes no sense.
Isn't the answer in 4A? Can you just turn to 4A for a second? I don't know if you have the language in front of you. 4A 1D. These are the factors that are supposed to be considered in determining whether a species is listed as endangered or threatened. In D says the inadequacy of existing regulatory mechanisms. Couldn't the service say, ordinarily, we have 5 criteria that you need to meet before we list you as endangered? If you meet 3 of them, we list you as threatened. If you don't make 3, then we don't list you at all. And they say, well, this one meets 3, so ordinarily it would be threatened, but it looks a lot like, and we have this laundering problem, and we're worried about whether this listing is threatened would impact this other species that looks very similar that we are listing as endangered. So maybe we should just go ahead and list this other one as endangered also instead of as threatened. Why couldn't the service do that relying on 4A 1D?
Because 4A is very specific to the species that is being listed, and 4E is there for this other lookalike species. Looking back,
what does inadequacy of existing regulatory mechanisms mean?
I think I think we're talking about the same thing, Your Honor. Clearly, it's the inadequacy of existing laws protecting this listed species under 4A. I don't read that provision as providing this authority to regulate trade in other species. That's what 4E does for these lookalike species.
And isn't it also, if it's just because of lookalike, which could be described as existing regulatory mechanisms, although you've just said no, but the treatment as is generally more tailored. It has to do with commerce and importation. It doesn't carry with it. Like if I were the Fish and Wildlife Service and trying not to overburden the already taxed resources of the service, I wouldn't want to gratuitously I wouldn't want to use the 4A authority to deal with a lookalike problem, because that carries a lot of burdens that have to do with actually the habitat and recovery of species that you wouldn't need for a species that is not itself suffering, but that's just a lookalike kind of proxy. So you want to get the interpretation of 4E to do that work.
Yeah, I think
because
this,
it's like a leaner authority.
It's consistent with the statute. And the service would kind of have to tie itself into knots to ignore 4E to try and do the same thing through 4A. And I do think that would be vulnerable to challenge. I see I am over time. I do, just want to briefly point the court's attention to something on the untimeliness argument. That's been briefed extensively. I didn't intend to, get to it in detail. But on page 7 of the joint appendix, it's the last docket entry from the district court. The district court denied the agency's motion for a stay of the explanation that it provided pending appeal. In assessing why the agency was unlikely to succeed on the merits of this appeal, the court writes in here, and since then, plaintiff has developed additional arguments why the appeal should fail. The only additional arguments that we had raised in briefing before that district court were ripeness and untimeliness. So the district court, this clearly suggests the district court believes that its July order was the order that triggered the agency's time to appeal. If it didn't believe that, it wouldn't have written this sentence. And what the district court's intent was in issuing the July order with an accompanying 63-page memorandum opinion is controlling as far as whether that is the appropriate order that started the clock for the agency to appeal.
Right, thank you.
Thank you very much, Your Honors.
Mr. Henderson, watch 2 minutes.
Just briefly, Your Honors, I'm sorry. On Mr. Hernick's last point, I don't know what the district court thinks of the time of Friend's timeliness arguments. Acknowledging that it made arguments is not the same as endorsing those arguments. We did not brief the adequacy of those arguments in our motion to stay, so I think that that carries no weight. Other than that, I have nothing further unless Your Honors have additional questions.
You may have already answered this, but does Section 4D allow the service to implement protective regulations for the sake of preventing the lookalike problem, or does only Section 4E do that?
The service has historically interpreted Section 4D to allow it to accord a listed threatened species any of the Section 9 prohibitions for any rational reason. So the first sentence says of 4D says that the secretary may prescribe measures that are necessary and appropriate. And the second sentence says without qualification that the secretary may apply any of the measures in Section 9. This court upheld that determination under Chevron. I apologize, I don't have the citation in front of me.
But if it's not a listed species, but a species that is going to be treated as.
Right.
So like the situation of the Southern DPS.
Mm-hmm.
Is there regulatory authority with respect to the Southern subspecies, Southern DPS, to regulate under 4D?
So once the Southern subspecies is treated as threatened, the service applies the 4D rule to
Okay. That's my
yeah,
answer.
that's how that works, yes.
Okay. So even though it's not listed.
Even though it's not listed, because the 4E says that the secretary may, as he deems advisable by regulation of commerce or taking, treat the species as threatened, the secretary reads that authority as allowing it to apply the 4D rule for the threatened species to the lookalike species.
Is there a regulation that speaks to this, or is this just the practice?
It's a good question, Your Honor. I'm not sure. I will find that out and inform the court.
All right, thank you.
Thank you.
This honorable court now stands adjourned until Monday, December 8th at 20:30.